appearances, please.
Lee Heiss, lawyer guardian ad litem.
Ms. Sasha Thomas, counsel for the department.
Tabitha Applegarn, on the Center for Children Program Director, currently carrying her foster care case.
Michael Brooks, I represent the respondent. Gunnar Wright. Mr. Wright, are you here?
Thank you. I do see you logged in under SDF Hearings West. Gunnar Wright, can you hear
Mr.
us?
Wright, can you hear me? Mr. Wright? Mr. Wright, can you hear me?
No. All right, so I guess we'll take a recess and see if we can. Can you hear us, Mr. Wright? We'll have to take a recess and see if we can't find somebody to call over there to talk about their issues. Which basically just laid out the fact that we need to move forward on the petition as it is written and with the review and the permanency planning hearing. Anything else about that sidebar for the record, counselors?
No, Your Honor.
No, nothing.
No, thank you.
All right, well then let's get to it. For purposes of the termination trial, some of the grounds alleged are as a result of failure to progress on a case services plan, and some of the grounds are as it relates to additional things that have happened, which although, for example, the criminal conviction seems to be an extension of some of the issues identified at the outset, which is the history of criminality, it could also be considered new information. So as it relates to how we're going to be proceeding on the issue of the burden of proof on those and whether or not the rules of evidence would apply under that context, Mr. Brooks, would you like to be heard?
Well, I would submit that the rules of evidence do apply on these new issues.
Your position is Thomas.
I agree, Your Honor, if we are alleging that new conditions have occurred since the child has been placed under this court's jurisdiction.
Ms. Heiss?
Yes, I agree. Any new allegations would require the higher standard of proof, evidentiary standard.
All right. Do you consider criminal conviction to be new circumstances?
I think it is his sentencing that would be new, and I have to look really quickly to see if that is new. However, I would submit that the sentencing document would be something the court could take notice, judicial notice of. There is no higher evidence of a sentence than a form CC 219B, which is a judgment of sentence and a commitment to the Department of Corrections that appears to be an order. It is a local order of Judge Olsaber, so that I think that it would meet the standard if it's considered new evidence. I mean, a new allegation since the time of the adjudication.
Very well. All right, so for purposes, I mean, I will say there is definitely a history of criminality alleged in the original petition. So I think really the issue is mixed at best. But for purposes of clear and convincing evidence, certainly, no matter how I look at it, it will have to meet that particular standard for purposes of termination. So, but we'll separate those for today, where we would usually consolidate them, I think, so we'll try it that way. But let's take the review and permanency planning hearing first. Ms. Heiss?
Thank you, Your Honor. I was able to visit with this child face to face. She is placed with a maternal relative, and she is meeting her developmental milestone. She is able to look to her caregiver when she is unsure of herself. She is able to manipulate with her fingers for fine motor skills. She's able to touch her toys that make a noise when she touches them in response. She is, when I visited, I think when I visited within the last week or two, she was standing and holding herself against a table. She is eating well and sleeping very well, which is good for even the caregiver. She has developmentally appropriate toys in the home. She has caregivers in the home around the clock so that she isn't required to be in daycare. She is enjoying normal traditions and holidays, and she also visits with a paternal aunt. dad's sister, and she enjoys that time. That visitation has slowed down or fallen off, and I believe that aunt works out of town often. So that schedule will have to be revisited to make sure that she has all the family that she has accessible to her, so she can, I believe that will be a competing party for if there is an adoption, if this child is available for adoption, I believe she'll have family members available so that adoption is likely within the family. She has not had contact in this last review period with either mother or father. Her mother has released her rights, but as a family, they recognize the mother. In this family, they kind of use nicknames so that I think the baby's called Chicky or something. And then I'm not sure what her word for mother will be, and her word for aunt that she'll know as mother, her maternal relative. There is extended generations in the same household, which really benefits this child. She is the focus of the house. It's a very child-centered home. This child is up to date on her medical and dental. She does not flag for any developmental services at this time. And then that concludes my comments. I reserve time to articulate on the best interest factors if we get to that point in the trial. Thank you.
Ms. Thomas?
Thank you, Your Honor. If Ms. Applejohn can please be sworn into the report.
Madam Chair, please stand. Thank you.
Good morning, Ms. Applejohn. This hearing was originally scheduled for April 24th, I believe. You provided a court report for that hearing, correct?
Correct.
And did you provide any subsequent reports or memos?
No, there was no updates as of last week, but this week she actually had her dental appointment, so she is now up to date on her dental. That is the only update from my court report.
Thank you. And in addition to the factual updates, are there any modifications that need to be made to the report or any of the documents that you included?
Not at all.
And the documents that you've listed on the court cover letter include the protecting information form, the case service plan for Mr. Wright, the court report, a sentencing form, and then the proof of service. Is that accurate to the best of your knowledge?
That is correct.
And as it relates to the sentencing form, can you please explain why you included that for this report hearing?
I included it that way attorneys and the court was just aware of his new, the new charges that he is now serving for.
I couldn't hear the last part of your answer.
I'm sorry, I included it just for the attorneys and the court. That way the everybody was aware of the new sentencing time that he's serving right now.
Thank you.
For whatever it's worth, it's going to come up, so we might as well get it done. I'm going to object to any reference to the sentencing report in the absence of someone who can establish that it is a regular business document used in the ordinary course of business by some arm of the Department of Corrections, and I don't believe this witness can provide that verification.
Thank you, Your Honor. I would like to, I would ask the court at this time to take judicial notice of the sentencing, the judgment of sentence commitment to the Department of Corrections, as I believe it is a valid court order that speaks to adjudicated facts that this individual was found guilty of home invasion first degree and minimum sentence of 42 months, maximum sentence of 240 months with the 136 days served. The defendant was also, or Mr. Wright was found guilty of this offense on August 24th of 2022, but our trial for Mr. Wright, I believe, took place on November 7th of 2022. So even as it relates going back to, is this new information, it was available at the time of the trial in which we did have a trial on this, and Mr. Wright did testify stating that he was found guilty and that the only thing he did not know is where he would be going to prison. So for those purposes, I don't know that we necessarily have to utilize the rules of evidence because it was discussed at his adjudication trial.
This is new information that's being added to the petition as it currently exists. And the rules of evidence apply because it's new information. And the rules of evidence should be complied with before it can be introduced.
Well, I did intend to bifurcate the evidence on the termination trial and the evidence as it relates to the review and permanency plan hearing. But I respect your objection, Mr. Brooks, as obviously this piece of evidence is something that will be used under both aspects of today's proceedings. So as I look at the rules of evidence, on the issue of whether or not I can take judicial notice of this, the scope of the rule, it does appear to be within the scope of the rule. I think the issue is best captured under 201B2, whether or not this particular piece of information is capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So I think the question is, can we reasonably question the accuracy of this particular document? As it relates to your first aspect of your objection, which is that it's hearsay, your defense to that, Ms. Thomas, was twofold. Correct me if I'm wrong. One, it's waived because it was raised in the adjudication. Second, that it's a public record.
Correct, Your Honor.
Or a record of regularly conducted activity.
Your Honor, I believe that it's an adjudicative fact that this court can take judicial notice of.
Subject to qualifications, Your Honor.
And so what more, Mr. Brooks, would you want?
Well, I can't cross-examine the document, obviously. I think and since it's a local document, I think someone from the appropriate agency or department in this very building could come up here, review it, and determine whether or not it is part of their regular business records made in the ordinary course of business. You just have to go up one floor or down one floor to get the right person who would have the ability to testify as to its veracity. And I think that should be done.
Any further response?
Your Honor, I respectfully disagree with Mr. Brooks. I believe that the court accurately stated the standard here, that it's whether it's capable of accurate and ready determination by resort to resources whose accuracy cannot reasonably be questioned. And I believe that we have that here, a document with Judge Olsaver's signature, and it's dated accordingly.
Well, I'm not asking that Judge Olsaver be brought up here to testify as to the signature, but I am asking that someone from probably the third floor review the document, look at the files in the court, and see if it's a part of the regular type of document that is prepared in the ordinary course of business in criminal cases. I don't think it's a big problem to get that verification. In fact, I think it's probably quite easy. And I cannot cross-examine a sentencing report.
Judge, we heard Ms. Heiss.
So with respect to the review, I think we admit, we would say that comes in. So to argue towards the adjudication or the termination, I would ask the court maybe to take it in, delay hearing on that until we can have the father himself testify and see if we even need it. And then maybe it would be redundant with his testimony of the same thing. I think it's a different way around the same thing, and we could, if we haven't met the evidentiary proof that we're expecting through the father, then we can go back to this document itself, but I think he'll be able to give us more primary evidence.
That would assume, in light of what I'm objecting to, that I am even willing to call him as a witness. Or that I will allow him to testify.
Your Honor, if I may, I just want to clarify that I'm asking the court to take judicial notice of an adjudicated fact, not entering evidence through the ordinary course of business.
I'm sorry, I couldn't hear the last part of what you said.
That I'm not asking it to be admitted under a document that's kept in the ordinary course of business. So two different standards or rules apply.
Then what is the standard you're using?
As the judge said in Rule 201B, subsection 2 of that, it's judicial notice of an adjudicated fact So the standard would be that a judicially noticed fact must not be one subject to reasonable dispute, in that it is either generally known within the territorial jurisdiction of the trial court or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. And I believe that this document satisfies that standard.
Thus, my request that you have someone from the appropriate department in this very building come up and verify that's what it is.
All right, I appreciate the arguments. I do think it is admissible under the request to take judicial notice. At best, I think we could have asked you, Ms. Thomas, to have it certified by the circuit court. So as we look at whether or not that is or should be a requirement for purposes of the termination trial, I will table that. But for purposes of the review, I am happy to take judicial notice of that particular document. But to consider it, I think the strongest position for purposes of termination would be if there were available to us a certified copy. So. But even then, I think you still have some grounds for that, but I'll table that particular conversation for when we get to the termination stage of things. But for now, it is admissible for purposes of the review. So the objection is overruled in part and preserved in part for purposes of termination.
Thank you, Anna. Ms. Appledorn, as relates to your court report, during this past review period, can you just please highlight, or if there's anything you need to add as relates to complying with like the incarcerated parent protocol, your policy, can you please just, for the record, let us know how you complied with that protocol in this case?
Yes, the previous caseworker did send the week 1 through 4 of the parenting education to Mr. Wright. As I was speaking to Ms. Thomas, I did forget to include that we send email, or not emails, I'm sorry, we send letters to the incarcerated parents once a month. So that wasn't included in my report.
And those letters that you send out once a month, what are the contents, or what information are you providing to Mr. Wright?
So quarterly, we have to send out medical passports, which just identifies the medical appointments or dental appointments. Obviously, those dental appointments weren't included because she just had her first one this week. We also have to send out the parent agency treatment plan quarterly, and then typically it just gives, the letter just gives our contact information. We try to send it in stamped envelope. However, usually that's compensated by the correctional facilities because they consider it contraband. But we try to include it just to try to help facilitate those letters back to us if we could.
And you are using the word tried in this. Did you in fact send self-addressed stamped envelopes to Mr. Wright in your correspondence?
Yes, but I believe that they were compensated by the facility, as I know they usually are. I should say that we didn't get anything back, so that's why I came to that conclusion. I'm sorry.
And have you been able to make contact with the current facility where Mr. Wright is located?
Yes, on several different occasions, we've contacted the warden's secretary. We just asked what services that we could try to sign Mr. Wright up. They said that they stated on multiple occasions that they're not that type of facility and they don't offer those services. If he is to be moved, then we can look at services in that facility.
And a lot of the petition, but also the court report indicates that many of the non-compliance is due to incarceration. Is that correct?
That is correct, and him serving a minimum of the 3 years.
At this current time, or during this reporting period, do you recall what the permanency goal for this child was or is?
Reunification with the concurrent goal of adoption because mother's rights were released.
Okay. And although there was still this reunification goal concurrently with adoption, you filed this petition against Mr. Wright. And can you please explain why that is?
Because he cannot start planning for Elizabeth until he's released from the correctional facility, because there's no services that are offered and we cannot provide those services. And then when he's released, it would be a minimum of 6 months to a year until that. So we're looking at a minimum of 4 years before he can potentially maintain custody of his child.
My silence shouldn't be construed as approval of allowing that testimony, Your Honor, but I think you've already ruled that it's admissible for the purpose of this hearing.
Thank you. Duly noted.
And during this review period, has there been any contact with Mr. Wright and the child?
No, there has not.
Have you attempted to send any photos or anything like that in your letters to Mr. Wright?
No, we just give them updates in the letters that we send to the correctional facility.
And do you know, like, parenting time through an electronic method is available to him at this current facility?
When we spoke to the warden's secretary, she stated that no services were allowed due to the type of facility, and that included the parenting time, parenting education, therapeutic services. We really tried to see if any services were available for Mr. Wright in order to start him in anything.
And the child is with a relative placement, correct?
That is correct. She's with maternal aunt.
And you said it's the maternal relative. So has Mr. Wright benefited from any of the advantages that a relative placement typically offers a family, such as the increased contact, family events or things together?
Before his incarceration, I don't believe that he was in contact with the child at all. And then after the incarceration, it was unable to occur.
And it is known that Mr. Wright has asked the agency to explore his sister for placement, correct?
That is correct.
And can you just briefly outline, I know it's already part of the record, but can you briefly outline the efforts put forth to that?
Oh, absolutely. So the paternal aunt is currently getting licensed through our agency. She is offered once a week visits, I believe on Wednesday nights. I cannot remember the time off the top of my head. It has been canceled by the paternal aunt recently due to her work schedule. But the maternal aunt makes sure to try to reschedule on the weekends or other days with her because the maternal aunt really wants her to have that relationship with the paternal side of the family, and she knows that it's beneficial when she gets older. So if it's unable to happen on Wednesdays, she has made other accommodations, but right now with the paternal aunt's own children's schedules and her work schedule, it's been quite difficult the last couple weeks, but I know that they're in quite communication, even texting and sending pictures back and forth.
Is there any reason to believe that the maternal aunt would stop supporting that relationship with the paternal side of the family if the court were to terminate Mr. Wright's parental rights today?
Obviously, I can't enforce anything after if an adoption were to occur. However, maternal aunt really has went above and beyond and out of her way, in my opinion, and really try to go the extra mile for those visits. So I believe that she wants that support because she said the more family, the better, because she is a single caregiver. So she figures when she gets older, she's going to need all the support she can get.
Has Mr. Wright, to the best of your knowledge, provided any financial support, material support to the child?
No, the child was released from the hospital into foster care, into maternal aunt's care, and there's been no financial support.
Does any support come from the paternal aunt? Any materials or anything like that?
No.
Is there anything else you'd like to bring to the court's attention for purposes of the review and permanency planning hearing?
Just that Elizabeth is thriving in her current placement. She went, as the court knows, she was born positive and was in the hospital for a period of time and was withdrawing, and you don't see any concerns at that matter. However, we are still trying to get early on involved just because of the born positive factor, because she was denied for services because she meets all the milestones, but just because of that born positive factor, we're trying to kind of fight a little bit with early on to get them to work with her until she kind of ages out of that.
Do you believe that at this point in time, adoption is the most appropriate goal for the child?
I do believe that's the most appropriate goal for the child because father cannot provide anything for her for up to 3 years, and she deserves permanency due to her age.
And no further questions, Your Honor, of this witness. And move to admit the court report with the attachments.
Recognizing your objection.
With that objection, I have no further objections. You can accept it.
Thank you. Ms. Hicks.
I have no objection, thank you.
Very well. The report and exhibits, including that sentencing document, are received for purposes of the review and permanency planning hearing. Questions for this witness, Mr. Brooks?
I have one. Would you agree with me, ma'am, that given my client's current circumstance, he is not able to provide financial support, he is not able to visit, and he is not able to comply with the case service plan?
I believe the consequences of his actions have made him unable to provide support and see his child, and yes.
Nothing further.
Ms. Heiss?
Do you know of any resources that Mr. Wright has that he can direct towards the care of this child?
Not that I'm aware of.
So he doesn't like own a house that he could sell to buy diapers, for example, correct?
Not that I was made aware of.
Okay, he hasn't offered any cash out of a savings account that he has available to pay for her food?
No.
So is he contributing at all to her housing?
No.
So he has, and then he has not visited with the child since, when was his last visit?
It was right in the beginning of the case opening. I cannot tell you the date off the top of my head. I apologize.
In your experience with your professional training, would you expect there to be a bond between a child who's 12 months old and has not visited face-to-face with a person?
Objection, I think, simply saying, based on your training, it's not going to move this beyond speculation on the part of the witness.
Should probably check into her training, if you would allow me that, and then we could tell.
All right, I will table the objection. You may lay some foundation.
Thank you. Tell me about your educational background.
My educational background includes an associate's degree in mental health and social work, a bachelor's degree in social work, a master's degree in social work, and I have a certificate in child welfare.
Tell me about your work experience.
I was a foster care and adoption worker for 3 years. I was promoted at 3 years to an adoption and foster care supervisor. I was a foster care and adoption supervisor for 2 years, and I have been a program director for approximately 2 years. I have 7 years in child welfare currently.
In your training, have you studied child bonding?
I've studied child bonding, child development, psychology of child development.
Okay. Do you and have you observed this child specifically?
On multiple occasions, yes, over the last year.
So you were supervisor on this case, and now you're filling in for the direct care worker?
That is correct.
Your Honor, I would ask to have her qualified to answer my questions about child development and bonding.
Further objections?
I have no response, but I do object on the grounds of speculative.
Very well. I do think she's qualified to answer those questions. We will overrule that objection. You may ask the questions.
In not relating to this child, but in theory, a child's bond in the first year, can you tell me something about how that develops?
Develops by trusting their care, ultimately their caregiver, but anybody that provides care, such as daycare providers, knowing that your needs are going to be met. If they're hungry and they don't get fed, they're going to have a less bond. If they need to be changed and they're not changed, that's going to contribute to having a less bond. If you're not seeing that caregiver when crying or fussing or seeking out attention, that's going to make you have a less bond with your caregiver.
Okay, in this particular case, has this child been exposed to seeing Gunner Wright's face when she had a need?
No, not that I'm aware of.
Have they ever had the experience of child expressing a need and Wright fulfilling that need?
Not that I'm aware of, no.
This child is not old enough to speak, is that correct?
That is correct.
So she's not expressing any wishes, correct?
That is correct.
Back to theory a minute. A child, in order for a child to bond with an adult, it sounds like you're saying that a person must in some sense be present to meet needs.
Correct.
Back to this case, is there any reasonable belief that this Gunner Wright will be able to meet the needs of this child in the reasonably foreseeable future.
No, I don't see that possible.
Okay, off of that topic now, are you seeing any developmental red flags for this child?
We always have to keep an eye on pretty much everything just to ensure that we make any recommendations or referrals needed. I haven't noticed anything in particular. However, because she was born positive, we want to ensure that, like I said, that early on, we're kind of butting heads a little bit to ensure that services are being provided. And that's not because her developmental milestones aren't happening. It's because of that born positive factor, we want to ensure that it continues on the right track.
The family that this child is placed with is related to the biological mother, correct?
That's correct.
And do they have a foster license?
No, they're unlicensed relative.
Do you know whether they're available to provide permanence if this child should become available for adoption?
They have stated that if parental rights are terminated, they would, the current caregiver would absolutely adopt.
And as of this date, there are no violations of their placement agreement, correct?
That is correct.
So this child is biracial, would you agree?
Yes,
So part Hispanic, part Caucasian.
that is correct.
In this placement, is the child exposed to her culture, or both of those cultures?
Yes, that is correct.
Can you give me any example?
I believe just having I believe you stated it for the record, the multi-generational in the household. They do sometimes speak Spanish as well as English. And I believe that they will educate her when she's a little bit older on the holidays and things like that. I don't think right now she's able to understand those things.
It may have already been asked, but I want to ask one more time. There's no opportunity for this father to visit in person in his current situation, correct?
Ask and answer.
Thank you. Nothing further, Your Honor.
Oh, any redirect?
No, Your Honor.
Any recross?
No, Your Honor.
Thank you for your testimony. You may return to your seat. All right, let's have argument then at the conclusion for purposes of today's review and permanency planning hearing.
I'm sorry, Your Honor. At this time, I believe that it's appropriate to ask for the will to be formally changed to adoption for this child. Know that there have been efforts put towards reunification and adoption for this child throughout the duration of the case. Unfortunately, with Mr. Wright's incarceration, those efforts are limited as to what they can be. I believe that we are following the incarcerated parent protocol by sending the monthly correspondence, reaching out to the facility to determine available services. So I would just ask that at this time, the goal formally be made adoption and only adoption for the child's permanence. Otherwise, we just ask the court to recognize that the child is in the least restrictive environment to ensure her safety, and she has been there for over a year now. She's developing well and meeting her milestones despite some, I suppose, a risk factor at birth. And otherwise, that is all I have for purposes of the review portion.
Mr. Brooks.
The issue before the court is whether or not the goal should be changed, not whether parental rights should be terminated. And based on that premise, I have nothing further to add.
Very good. Comments, Ms. Heiss?
Your Honor, I know that we're going to go into termination is the next phase, but I would ask you to consider at this point changing the goal to adoption, but also ordering that no reasonable efforts need to continue. There is a termination petition in place. We don't seem to be getting anywhere. I do appreciate the compliance with the incarcerated parent protocol. The goal has secondarily been adoption as a shadow going along. So I think that at 14 months old, this child needs to have all the resources directed towards helping her relative or the competing relative or both provide permanence for her. So I'd ask you to order that no reasonable efforts need to be made going forward. Thank you.
All right. Well, the court finds all interested parties were given notice for purposes of today's review hearing and permanency planning hearing. We've had a couple of adjournments, but no substantive changes in the situation that faces both Mr. Gunner Wright and the child at this time. I do find reasonable efforts towards the goal of reunification by way of compliance with the incarcerated parent protocol, as well as the dual planning for adoption and considering placement and all of the information offered in the court report, as well as the exhibits, constitute reasonable efforts towards those goals. So thank you, Ms. Appledorn. Thank you also to Ms. Heiss for her compliance with the statutory obligations as guardian ad litem.
Thank you.
I have considered the appropriate goal for this child, and given the circumstances facing Mr. Wright, it does appear that adoption is the correct goal for the child. At this time, services are unavailable to him as a result of his incarceration, which is a direct result of his actions within our community. He did not direct care or custody or intervene at the time when the child was born, even though he was not incarcerated at that time, or even if he was incarcerated or incarcerated shortly after that, he did not make arrangements for family members at that time to take care of the child by way of guardianship or any other arrangements, nor has he done so since that point. There are significant limitations on what is available to him in the facility presently, and the information and parenting education that has been sent, as well as the updates, have gone unanswered. So for all of those reasons, I do find, as well as I should say, the child's young age, need for permanency and stability, and success in the current placement all lend support for the court's decision to change the goal to adoption in this case. As to the directive on whether or not reasonable efforts should be continued, I'm not going to make that determination at this time. I will wait until after we've had a chance to hear the evidence on the termination petition before I make that decision. We are, however, going to take a brief recess before we get into that sidebar aspect of today's proceeding with the attorneys to discuss a few things, including the grounds for termination moving forward. So any clarification on that or anything else for the record about the sidebar, counselors?
Your Honor, I believe that we can, in my argument, I will make those distinctions. I believe that the petition as filed does need some modification. It is my intent to bring that to the court's attention as I have brought it to council's attention. Otherwise, we were able to secure a certified copy of the judgment of sentence, which was part of the issue that we had discussed as well. Otherwise, I do not have anything else to add.
Mr. Brooks?
If I could figure out a grounds to object to its submission, I would, but I can't.
Anything else about the sidebar, Ms. Heiss?
Nothing else. Thank you.
Very good. All right, let's head into testimony and presentation of proofs on the termination petition. Any opening comments?
Your Honor, I'll wait opening at this time. Thank you.
Mr. Brooks?
I have no opening, Your Honor.
Ms. Heiss?
I intend to rely a lot on the review, and I think that the level of proof is there, but and I would like to offer that my recommendation is that the termination is in the child's best interest, that there is a preponderance of evidence that the best interest of the child would be served by allowing her to enjoy permanence and look forward to a permanent resolution of her care.
The only response I would have is that preponderance is good for best interest factors, but not for termination.
That's true. That's true. But I think we all know we're looking at clear and convincing evidence standard for the first part of the termination. All right, Ms. Thomas, witnesses.
Thank you, Your Honor. At this time, I would ask the court to take judicial notice of the judgment of sentence. We were able to secure the certified copy. I have allowed counsel to review that and confirm that it is certified. And so I decided to ask the court to officially take judicial notice of the length of sentence that Mr. Wright is serving.
No objection.
No objection.
Deputy Ames, if you wouldn't mind passing that along to me, please, that would be petitioner's, that's exhibit 1 for purposes of the termination.
For purposes of the termination hearing, I do not have any witnesses.
Mr. Brooks?
Mr. Wright, do you wish to testify, sir? I don't believe that's a live picture.
Okay. All right, well, we'll take we definitely need him for purposes of this hearing, so we'll take a break and get back in contact. As I previously announced, I also informed everyone before you got here, Ms. Heiss, that Mr. Brooks has had an opportunity to talk to Mr. Wright as well before we began. May I have appearances, please?
The Heiss, lawyer guardian ad litem.
Good morning, Your Honor. Nastasia Thomas, counsel for the department. Ms. Appledorn. Tabitha Appledorn, Program Director for Ennis Center for Children.
Michael Brooks, I represent the father of this child, Mr. Gunnar Wright. Mr. Wright, would you introduce yourself?
I'm Gunnar Wright.
All right, Mr. Brooks, I believe at the expiration of our proceedings last time, we had lost Mr. Wright, but you were about to ask him if he would like to testify.
That's correct.
So I'll leave it to you then to make that inquiry on the record.
Mr. Wright, the question remains from yesterday. Is there anything you want to tell the court? Any issue you want to cover?
Yeah, I want my child to go to my sister. I was trying to get that. And I don't think it's fair if you guys take my rights away. I just don't understand that. Because I'm only in here for like 2 more years. And you're saying I can't be a part of my daughter's life when I get out. I just don't understand that. That's all. I don't see why you want to take my rights away.
Would it be fair to say you are objecting to the termination of your parental rights?
Yeah, I don't want my rights taken.
I just rephrased it from what you said. That's all I did.
All right. Yes, sir.
Well, I'm asking you, sir.
Yeah, I don't want my rights taken away.
All right. All right. Is there anything else you want to say? This is your opportunity.
I think you guys should at least give me a chance when I get out so I can be a part of my daughter's life.
Would it be fair to say that you don't think it's fair that the biological mother who gave her parental rights up voluntarily is free to visit her family and at the same time her child? Is that right?
Yes, that's right.
And if your parental rights are terminated, you don't believe you'll be given the same opportunity?
I haven't got no opportunity whatsoever.
Is there anything else you want the court to know?
That's about it.
Thank you.
All right, okay, so we'll open it up. Ms. Thomas, for you, if you have any questions, if you could move a little closer to your microphone.
Thank you, Your Honor. I do not have any questions for Mr. Wright at this time.
How about you, Ms. Heiss?
Mr. Wright, what is your earliest release date?
Year 2025.
Thank you. I have nothing further.
Anyone else you'd like us to hear from, Mr. Brooks?
Do you have a specific date, Mr. Wright, when the earliest release date is?
November 16th, 2025.
All right, thank you.
Closing comments, Ms. Thomas.
Thank you, Your Honor. This case, at the onset of adjudication, Mr. Wright was incarcerated, and we did know per his own testimony that he would be incarcerated for more than 2 years. The petition does not specifically allege the ground for termination under MCL 712A subsection H, which states that termination is appropriate when the parent is in prison for such period that the child would be deprived of a normal home life exceeding 2 years. And the parent has not provided for the child's proper care and custody, and there is no reasonable expectation that the parent will be able to do so within a reasonable amount of time considering the child's age. In this case, we have a young child who has been in care for the entirety of her life. At the time of adjudication, Mr. Wright had testified to substance abuse, the criminality, unstable housing, unemployment, and for his testimony and the sentencing, the judgment of sentencing, Mr. Wright will be in prison for 2 years or more. That would deprive this child, who is very young, of a normal family life with him. As this court mentioned yesterday in its remarks related to the review hearing and permanency planning hearing, Mr. Wright failed to take the steps necessary to ensure that she had proper care and custody at the time he became incarcerated. He is asking us, and well, frankly, he's asking his daughter to wait for 2.5 years minimally, just in case he does get released at his earliest release date for permanency and stability. And even at that point in time, there would be the expectation of complying with the case service plan becoming stable, and being able to provide for his child independent of our services. And that is not fair to this child. So we request you to consider the termination under that subsection. And we also believe that that meets the requirements for termination under subsection J, that there's a reasonable likelihood that based on the conduct and capacity of the father, the child would be harmed if returned to his care or his parental home. And we believe that his incarceration, his lack of provision for her, the instability, the criminality all speak to that element. And we believe that under both those subsections, there is clear and convincing evidence for you to make that determination. And as it relates to the child's best interest, I will be brief on that point, as Ms. Heiss typically does a very good job of arguing for that element. But I do want to highlight that the child is very young, I believe just over a year old, and has established a meaningful relationship with her current relative caregiver. And a relative caregiver placement is a required consideration when it comes to the child's best interest. And in this case, it does not weigh against termination because it is a maternal relative. And furthermore, this maternal relative is supporting the relationship with the paternal family. We believe that this maternal relative also is willing and able to provide permanence to the child while supporting those extended familial relationships. This relative has provided very appropriate care for the child in ensuring that medical appointments are met or completed. And the child is overall developing very well, as we've heard from testimony, despite the risk factors that are associated with drug exposure at birth. This child is not showing any signs of any developmental disabilities or delays or anything of that nature. So we believe that this court's intervention has been successful for safeguarding this child. So for those reasons, we ask that the court issue an order terminating Mr. Wright's parental rights and committing the child to the department. Thank you.
Mr. Brooks.
Well, to the first of my client's issues that he wanted raised and addressed by the court is his desire that his sister have the opportunity to have the guardianship and even beyond that, possibly the ability to adopt this child. I don't think up till now she's really been given that chance. The child was immediately placed with the family of the mother, and Mr. Wright points out correctly that he thinks it's ironic that the mom immediately dumped the baby. The baby now went to her family and she can really go see him anytime she wants, which I think is probably an accurate statement. He, on the other hand, has, for all intents and purposes, no opportunity to see this child. And if his parental rights are terminated, he never will. And he sees that as fundamentally unfair. And I agree with him. It is fundamentally unfair. And his sister, I think, should be given far more serious consideration as a potential guardian and future adoptive parent of this child than she has gotten to this point. Now, the only other issue that I can see on this record that I can raise is this, and that is the grounds on which termination is going to be based is going to be based on that section of the statute which says Mr. Wright will not be available to provide his responsibilities to this child for more than 2 years because of his incarceration. Well, that didn't come up at all. It's not in the petition and didn't come up until the termination hearing. And I object to using it. I object to it being used as the grounds for this termination, if you choose to use it, because of my complete lack of notice that it was something I was going to have to contend with until the day of the hearing. Thank you.
Thank you. Ms. Heiss.
Thank you, Your Honor. I think that the court can find that 712A.19B H has been met the fact that it is not in the pleadings, I believe you have the discretion to make findings on that. It is to ignore that would be to ignore the entire theme of the case, which has been since the petition was filed in April of 2022. Remember that the DNA wasn't back and we didn't find the official father for several months. In that time, Mr. Wright preferred the placement that the child is in now. So, his plea to have the child permanence be perfected in his sister is open. That's an adoption question if the child is available for adoption, and she has been visiting with the child and given visits. So she has her own attorney who is working with her on that. So it was Mr. Wright's choice to have this child put with the maternal family, and then when that now that he wants to change, I ask you to consider changing the focus and looking at the child. So in Mr. Wright's plan for the next 2 years, the state would take care of his child, and then the child would be about 44 months if he was released on his first out date. The child would be almost 4 years old, and in that time, the child would be the responsibility of the state, and then Mr. Wright would like the opportunity to get out and have a relationship with her. The fact that the child is in a family placement is good for the child. It's good for her permanence. They are very motivated as a relative to have this child have all the advantages and meet all her developmental milestones. It would be true in theory of the maternal family too, although Mr. Wright was on board with this placement in the beginning. So I would ask you to look at the best interests of ask you to find that the statutory requirements have been met by the clear and convincing evidence that the statute requires. When we separate and go into the best interest of the child, the family placement was put here to allow the parents to have extra comfort in the child's placement, extra access. We haven't had any evidence to rebut the fact that the child has no bond with this child, with his father, no visits, no mail, no nothing has been provided by the father. In this case, the child wouldn't know the father's been in placement since birth. I would ask you to consider that the family placement would weigh against termination. However, in this instance, it has not been available to improve the bond between the child and the father. However, without that, I know that Mr. Wright's defense includes what he wants for himself. He wants to be able to see the child when he is released in 2 years. He wants his sister to raise the child, but the best interest of the child, look at the child, and only in this place can we look at the advantages of the foster home over the parent's home. So at this point, and for 2 years going forward, this child has an incarcerated parent who is not available to provide for her developmental needs. And I think that's irrebuttable, but I would ask you to consider there is no contrary evidence that it is in the child's best interest to terminate. The evidence that we have is that it's not good for the dad to terminate. He wants to, when he is released, continue his relationship with the child. I don't think that that is contrary evidence to overcome our preponderance of the evidence that it's in the child's best interest. However, we have the agency who testified with her advanced degrees in the area and experience that the bond between this child and her caregivers includes trust has been built. The child knows that her needs are met in this placement. Therefore, she is developing and meeting her developmental milestones on target. There are no red flags for her development. We can't really determine the child's wishes at this age. She's 14 months old and unable to articulate. There has been no history, though, with the parent to show us what she does and doesn't feel when she's in the presence of her father. So there really isn't a comparison, but there again is just a lack of evidence to rebut hundreds of evidence that we've found regarding the best interest of the child. There is a high likelihood that this child will receive permanency within the family. So the testimony was that we have visits occurring between the paternal family and this child, that people are being licensed. I mean, the placement is being licensed, and that the maternal and paternal father sides of the family will both have access to this child should she be freed for adoption and permanency through that avenue. There are more than one good candidate for that. We heard that this child is biracial and that her ethnic and cultural heritage are both being explored and expressed for her so that she will grow up knowing both sides of the family and that background. She doesn't have any siblings that are in care. Earlier in the case, we found out that both mom and dad have many children who are not being raised by either mom or dad through different situations and different organizations of those children, but she does not have siblings with whom she is bonded at this time. The parents throughout the case have been either incarcerated, missing in action, or the mother released her rights early on, and father has been unavailable to show us his parenting techniques or his history of parenting. That became irrelevant. We can look in the foster home and see that those are happening for this child. She's meeting her developmental milestones as a result of the parenting techniques of the placement. We know especially that it will take more than 24 months for this father to rectify the risks that brought the child into care. What should the child do for her needs for the next 24 months? She will be progressing through milestones. As we heard, my report as well as the caseworker's report indicated that the child's meeting her 12-month milestone. She is pulling herself up and walking along furniture. She is looking at someone when they call her name. She is eating and sleeping well. She has extended family in the same placement that live with her. She has developmentally appropriate toys. She is up to date on her medical and even dental appointments. There continues to be monitoring by the agency. I would ask you to consider that it is my recommendation from my visits with her throughout her life that the placement is meeting her needs and that the statutory basis has been met in this case. And in addition, it is in the child's best interest that parental rights be terminated so that she can find permanence through adoption. Thank you.
Thank you. Well, the court finds all parties were given appropriate notice for purposes of today's hearing. Today's hearing was continued over from yesterday in order to allow Mr. Wright to participate in the trial. He was removed as a result of some of the practical aspects of living within the confines of the correctional facility that he's at. And so in order to accommodate that, we moved it to today. He was also given the opportunity to talk with Mr. Brooks ahead of time. I know the court will issue its opinion on the proofs as it stands as it relates to the request for termination of his parental rights. The termination of parental rights is separated into two phases. The first is to determine whether or not there's clear and convincing evidence under the statutes to determine that termination is warranted. The second is to decide by a preponderance of the evidence whether or not it's in the best interest of the child to terminate parental rights. Specifically, the court has been asked to look at two different sections of the statute when applying the analysis and the burden of clear and convincing evidence. And of course, those were articulated by Ms. Thomas. The first is subsection H, whether or not the parent is imprisoned for such a period that the child will be deprived of a normal home for a period exceeding 2 years, and the parent has not provided for the child's proper care and custody, and there is no reasonable expectation that the parent will be able to provide proper care and custody within any reasonable time considering the child's age. The court received into evidence yesterday a certified copy of the judgment of sentence commitment to the Department of Corrections regarding Mr. Gunnar Dean Wright. It reflects that there was a guilty plea to a charge of home invasion first degree, a violation of MCL 750.110A2. It also indicates that his sentencing date was 9/29 of 2022 with a minimum of 42 months and a maximum of 240 months with his date of sentence beginning 9/29 of 2022 and credit for 136 days. By his own testimony, his earliest release date is over 2 years from today. And so the first section of that statute, the court does find that there is clear and convincing evidence to establish that The parent is in prison for such a period that the child will be deprived of a normal home for a period exceeding 2 years. The second part of the statute is whether or not the parent has provided for the child's proper care and custody. Mr. Wright submitted to some DNA testing in this case in the summer of the child's birth. He was then absent from the child's life. He was absent from the court's proceedings as well. I have reviewed the record, and the court orders reflect that, for example, the date of the original adjudication trial, neither parent appeared. We had adjourned to allow a better service, documented service, on the date of the pretrial hearing. We did not have Mr. Wright. In other words, he was not interested enough to know where his child was or what needed to be done in order to provide proper care and custody for her at that time. As of July 18th, 2022, again, we looked for proof of service specifically, but Mr. Gunnar Wright was present for that hearing courtesy of the Lenawee County Jail. So the petition is accurate when it notes that Mr. Wright was not incarcerated at the outset of this particular case, but was absent, in fact, from his daughter's life for that period of time, which certainly constitutes.
I even talked to the CPS.
Mr. Wright. Okay, Mr. Wright, your opportunity to share your side of the story has lapsed. All right, so as I stated before, he failed to, at that time, provide, for example, an affidavit or power of attorney granting a family member, or, for example, a guardianship or anything else, or frankly, to take over care and custody of that child at the outset of this case. And then after he was incarcerated, did not pursue any of those avenues either. As Ms. Heiss noted, he in fact agreed at that point in time that where the child was placed was serving her interests. He was present at the July 15th hearing, which again was, and that is a pretrial hearing. And that was, of course, again, courtesy of the Lenawee County Jail. And for his adjudication on November 7th, 2022, he was present by Zoom, courtesy of the jail, for his trial. At the trial, it was found that, in short, he had an open felony warrant for dangerous felonies and lethal usage of illegal substances, was the language in the order. And as Ms. Thomas pointed out, there were significant issues in the area of substance abuse, criminality, lack of housing, and lack of employment. So in many areas, he had been unable or unwilling to provide support, education, medical, surgical, or other necessary care. Being in his home posed a substantial risk of harm to the mental well-being of the child, and that the home was unfit as a reason of his neglect, and as well as criminality. And that was the basis the court took jurisdiction. At the time, the court noted in that particular order that parenting time would not be granted as Mr. Wright had been absent, and no parenting time was even requested at that period, at that hearing. So I do find that proper care and custody was not provided by Mr. Wright, even though he did have a right to do that, and he had a right to, again, direct care and custody. And at the outset of the case, as noted by Ms. Heiss, he agreed with the placement of the child where she's at and remains. I cannot find, based on the demonstration that I've had on the record so far, that there's a reasonable expectation that he'd be able to provide proper care and custody within a reasonable time considering the child's age. Even if he was released from prison, he would have to show a significant period of sobriety. He would have to overcome the psychological, perhaps, or other barriers that would be presented in preventing any further criminality. He would have to establish housing and employment. So even if he were to be released at the earliest possible release date, he would still have a significant number of things to overcome in order to establish that he would be able to provide for this child. And I cannot find that that's a reasonable time for a child who is just over a year old at this time for her to wait. That's effectively approximately 3 times the amount of time she's been on the earth at this point. And I don't find that is a reasonable time frame to ask her to wait. As for the request for the child to be placed with Mr. Wright's sister, I would agree with Ms. Heiss that she's able to file a competing petition for adoption, and I would note also that she's being given visitation. So that's just an aside for the moment. That will be more relevant, obviously, in her best interest analysis as well. But I do find clear and convincing evidence under Section H for all those reasons. I also find clear and convincing evidence under subsection J that there is a reasonable likelihood, based on the conduct or capacity of the child's parent, that the child will be harmed if she were to be returned to the home of the parent. Obviously, Mr. Wright is not available to her, will not be available to her for at least 2 years, in 3 years approximately, at least, in order to overcome the barriers as previously analyzed by the court for significant issues, including, again, substance abuse, criminality, lack of housing, lack of employment. So for all those reasons, I do find there's also clear and convincing evidence under subsection J. As it relates to the best interest analysis, I want to take judicial notice of Ms. Heiss's remarks. I agree with Ms. Thomas, very thorough. Thank you very much for your analysis.
Thank you.
I will highlight some of those just to reiterate for the record. I want to recognize the foster home for meeting her needs and ensuring that she went through all the tests and monitoring necessary to make sure she didn't have any long-term effects as a result of being born positive for substances. I want to recognize them for providing stability and permanency for her that allows her to demonstrate at this point that she doesn't have any disadvantages as a result of being born positive for substances, and that she's meeting all of her milestones. Obviously, at this point, Mr. Wright's not available to provide housing, so that in and of itself weighs in favor of the foster home at this point, which is a relative placement, relative caregiver. Ms. Thomas is correct that this is not a relative of Mr. Wright. However, it is a relative of the child. And obviously, if they're willing to have a relationship with Mr. Wright's sister, they could have potentially had a relationship with him as well. And he is not taking advantage of that, nor any of the other potential opportunities as a result of a relative placement. Even, for example, granting a power of attorney or guardianship through EPIC that would have been available to Mr. Wright outside of this case, which could potentially be looked at as a benefit of relative placement, was not something he took advantage of. So despite the fact that this is a relative of the child, I think that it's clear that it's in her best interest to terminate Mr. Gunnar Wright's rights to her at this time. Again, she's only a year old. She's been in care for nearly her entire life, and relative placement that again is providing for her needs necessarily, appropriately, and is in her best interest to remain there, awaiting adoption, which is highly likely with the family members that she remains with. They are providing the also the ethnic and cultural considerations that she gets to enjoy to learn about her own background, and that's also good to hear and is a benefit to her. She does not have a relationship with her father, so bond is not something we can analyze. He was absent during the outset of the at the outset of the case, and then unavailable to her as a result of incarceration and declination of requests to even visit. So for all those reasons, I find that it is in her best interest, with the support of the analysis of our guardian ad litem and our caseworker, that the termination of the parental rights of Gunnar Wright to this child are in her best interests. As a result of that decision, there will be, of course, no further efforts towards reunification or to prevent removal. The child will be committed to the care and custody of the Michigan Department of Health and Human Services, now free for purposes of pursuing the goal of adoption, which will be the goal for her moving forward. Mr. Wright's sister is welcome to file a competing adoption, as we've already articulated, and to continue her visits to see if she truly wants to explore that. And hopefully she'll remain a part of the child's life as well moving forward. Mr. Wright will also have the right to appeal my decision. We'll send him a copy of the order, as well as the form requesting an attorney, and that attorney would be provided with the whole record and anything else that they would need in order to pursue that appeal if he so chooses to do that. Mr. Wright, you have 21 days to do that, so I would encourage you to make sure that you have a look at those documents and make that decision as soon as possible, so that if you decide to appeal, I can get that on its way right off. Well, unless there's any questions, that's all as it relates to the termination for today.